Welcome to the study session meeting for Farmers Branch. It is presently Monday, October 17th, 2022, 5:30 p.m. Study session item A1 is Planning and Zoning Commission training from the City Attorney's Office.
Good afternoon. I forgot we streamed this one, so I guess I'm going to have to stay somewhere near the microphone so people can hear me. Not that necessarily the folks at home really care to hear something that may seem a little bit dry. My name is Kevin Laughlin. I've been one of the city attorneys since, for now about 14 and a half years, almost 15 years, 14 years now, 14 years this month. And I'm with the firm Nichols Jackson here in Dallas, and been doing most of the land use work, advising the planning department for most of those last 14 years. And so I've had an opportunity to do this training a few times. Occasionally I'll do, maybe some of you saw, either attended the live or video version of board and commission training. Well, because we do have the City Secretary's Office does conduct that separate board and commission training, we will not be covering all the open records, Open Meetings Act type of issues today. I know, darn.
But still won't tell me what this training is about.
We're largely going to be a little bit on the nuts and bolts side because we do have a number of new folks to the commission. And we have not done much in the way of our true nuts and bolts type of training just for the Planning and Zoning Commission in past few years that has focused on just the land use type of stuff that you do. That's really the primary reason for this training session today. So we're basically going to hit kind of the highlights of zoning, detailed site plans, subdivision plats. We're going to do a little bit about meetings and talk a little bit about kind of how to handle meetings. Kind of what we recommend is some of the golden rules. Obviously, every chairperson has the right to handle the meeting how they want to, but like I said, I've been now doing municipal law, as I said, as of yesterday for about 33 years. My partner, Pete Smith, who's the designated city attorney for longer than that. And I think with our combined skills, we've kind of come up with some ideas on what works and what doesn't based on the hundreds and hundreds and hundreds of meetings we've been to over the years. And so, so I'll lay some of that stuff out, take it for what you think it's worth, but, hopefully it'll be something that'll also helpful as you go forward with cases and public hearings here in the future. We're going to kick off just basically talking a little bit about the kind of the basics of zoning and kind of the statutory basis as well as your ordinance basis. Basically, there is a chapter 211 of the Texas Local Government Code that authorizes cities to adopt zoning regulations. And so 21103 is the primary one that talks about the kinds of regulations that can be imposed. The use of the word zoning does not necessarily even always appear, but basically what you see on the screen here as far as what cities can regulate, that does constitute what your zoning is. As far as again, location of building structures, height and number of stories of buildings, size of buildings, your lot coverage percentages, your side yards, all your yard measurements, even population density, which we often get into when we're talking about multifamily units. We often talk about, how many units, and of course from that you kind of extrapolate your population density on how many units per acre that we do on density. And the one thing that home rule cities can do that general rule law cities cannot is we can actually regulate the bulk of buildings. Now, for the life of me, I don't know what the heck the bulk of buildings means. There's no defined term of what it means by the bulk of buildings, but it's something you can regulate. So just know that. And again, you can, and of course, the next step, as you're familiar with, is we have zoning districts. Cities can carve up their cities into different kinds of districts, basically in order to create these, in establishing their zoning. You can, and of course, we have that, as you know, we have different, we have a zoning map that has to be maintained that shows the boundaries of each of those zoning districts. And of course, within those districts, you can designate, as we know, through our comprehensive zoning ordinance, you can designate the regulations of development within those different districts. Now, zoning regulations generally must be uniform for each class and kind of building in a district, but as we all know, the district regulations can change. So, different types of uses or the same kind of use can have different regulations depending on the different zoning districts that you're in. So, for example, I think many cities, particularly this is true, for example, of residential districts where many cities will actually regulate your minimum air-conditioned floor space that's allowed in each kind of zoning district. Farmers Branch does not do that presently, as I recall, but many cities have, over the last number of years, have begun to do that, where they will put a minimum, for certain, say your smaller lots, zoning districts, they may allow for a 1,200 square foot single-family residence. And then as you go up to larger and larger lots, many cities will actually go up to larger and larger minimum square footages as well. And part of that's to, of course, some would say, well, that's to make sure you maintain your value and your tax base. Those who are a little more cynical in the way that cities zone that way. Others would say that is, and while that may be true, it's also a way to maintain property values because, based on the size and consistency within construction. Because as, basically, and Srupa, she may want to comment or she wants to correct me if I'm wrong. I'm more than willing. I've done doing this planning stuff for many years, but I'm not a professional planner. I'm just the legal guy. But the, difference, having too much of a variety and too wide a range of square footages within an area does have potentially a negative impact on market value. And part of the regulations, part of the purpose of zoning is to help maintain and protect property values.
So I have a quick question.
Yes.
So this says Texas local, or is that, what's the LOC?
Texas Local Government Code.
Local government.
That's,
So does every local government have to have a zoning code within their city?
No.
Some of these little small ones don't seem to, so they don't have.
Well, no, I'd say almost. Do you have to have zoning? No. I mean, Houston doesn't have zoning.
Houston doesn't have zoning?
Houston does not have zoning. Houston has historic, in fact, it's probably one of the largest cities, I mean, it is.
It is known.
It is probably the largest city, certainly the largest city in Texas, but maybe one of the largest cities in the country that does not actually have zoning regulations. They primarily dictate their land use through deed restrictions, through property covenants. And that's how that's developed over the years. That's why Houston is as crazy with respect to, inconsistent with respect to the way its land use has developed over the years.
That's why
Because
you
they've
have
never
the
had
medical
zoning.
Center and the Galleria and
I believe
downtown and the area
maybe-
around the park.
All together.
Yes,
4 separate places.
yes.
And maybe if you want to explain the home rule versus the
General law.
other general law cities, that might also give some
Yeah, let me
background.
tell you, okay, so, and then this is really not a zoning question, but it just kind of help you a little bit on that. General law, there's basically 2 classifications of cities within the state of Texas. And there's actually 3 classifications, subclassifications of the one type. First type are general law cities. General law cities are typically going to be cities with a population of less than 5,000 people. And they, much like counties, their sole authority is derived strictly from state law. you have to have state law to give a general law city its authority to do anything. So, and believe it or not, counties are the same way. Counties are not home rule in Texas. They all derive, if they don't have a statute that authorizes them to do certain, exercise certain powers, they can't do it. Okay. Home rule is just the opposite. Home rule cities, you can't become a home rule city until you've reached a population of 5,000 or more, at which time those within the city can elect to create a charter commission, and then they can then go forward and develop a city charter and have an election and decide to elect, have an election to adopt that city charter, and once that happens, they become home rule. Now, like I said, unlike general law cities, basically home rule cities, once they've adopted and become a home rule city, can do anything they can to regulate themselves subject to their charter and subject to what state law says they can't do. So basically, as long as your charter and your ordinances don't conflict with state law that prohibit or regulate certain, prohibit and limit state home rule powers, a city can pretty much do anything it desires to do, again, subject to its charter. So in that instance, now, general law cities can adopt zoning regulations as well. So they do have authority under Chapter 211 of the Local Government Code to adopt zoning regulations. So there are smaller general law cities that do have zoning. What you'll find is you have a lot of, particularly in, I'd say, the North Texas region, you've got a lot of very small cities that have adopted zoning in part, and as well as subdivision regulations that extend into their ETJs, largely because they are growing so fast, and in order to kind of make sure they coordinate and develop as they want to, even though they may not, they may have 1,500 people population, but they may have, before annexation was basically terminated by the ability to annex was terminated by the legislature, here, for all intents and purposes here a couple of years ago. A lot of small cities were continuing to annex as much as they could, basically in order to protect their growth and anticipation of future population growth as the larger cities and the larger suburbs continue to expand outward from the Dallas and Fort Worth centers. So, but a lot of those, because their population is under 5,000, are general law cities. So, now, because of, the sophistication, the size of the cities, their ordinances may not be as detailed and sophisticated as others, but they have something in many instances. Okay. And of course, as you probably know by now, Chapter 94 of the Code of Ordinances is where you can find the city's comprehensive zoning ordinance. Now, one thing about it is if you have a city that has adopted zoning, you must have a planning commission. There's no ifs, ands, or buts about that. State law mandates a planning commission. Certain general law cities can have their city councils serve as planning commissions, but home rule cities, if they have adopted a zoning ordinance, must have a separate independent planning and zoning commission. So again, kind of nuts and bolts of this body, you have 7 regular members, 2 alternates. The alternates, while this is not true in every city, the alternates, if they attend, actually get to participate in the deliberations on the cases. We've created that situation in our ordinances to allow alternates, if they attend, even if they don't get to vote at that meeting, they can still participate in the deliberations and asking the questions of applicants and staff as part of that part of the process. You serve 3-year staggered terms, and we set it up. We did a whole revision here, about 3 years ago, where we kind of realigned all the boards and commissions, and so we've got it set up. So basically, you've got let's see, there's 9. We've got 3 people, 3 seats that are up every year. And it kind of varies from whether it's 1 regular and 2 alternates or 2 regulars and 1 alternate. I mean, it kind of shifts through that process. And for the life of me, I mean, it was like putting together a Tetris, game, trying to figure out how we did all that when we transitioned, from what we had been doing to what the current rotation is now. But we did do that. Of course, you have to elect a chair and vice chair. We usually do that annually. 4 does constitute a quorum because you have a 7-member regular member body. 4 constitutes a quorum. Now, of course, that 4 can consist of, a combination of regular members and alternates if you don't have sufficient number of regular members in attendance to make up the 4. So that's why it's always it's really kind of important that alternates attend on a regular basis because you never know on a given meeting if something should happen that you may have fewer than 4 regular members in attendance. It's, with the 7-member body, it's usually rare. I've got a couple of cities where we only have actually 5 regular members, and so occasionally those alternates play a much more active role in filling in a slot when we don't have, maybe 2 of the regular members are not in attendance. And of course, as you're aware, meetings are open to the public and must be conducted in accordance with the Texas Open Meetings Act. I could probably go into a fairly lengthy list of your duties, but really it kind of boils down to about 3 categories. One is, of course, to carry out the duties under the comprehensive zoning ordinance and those pursuant to state law. Basically, to hear zoning cases and to make recommendations. Within that is your authority and your obligation to make recommendations to the city council on zoning cases that come before you. You also have the, believe it or not, and I had to remind, I was going back through this report and I'd forgotten about this, but actually planning commissions have the primary and initial authority under state law with respect to subdivision plats. Now, a number of cities, and we just made this change
Last year.
just a couple of, was it last year? About 2 years ago, I think. It's been, somewhere in the last year, 18 months. We made a substantial amendment to the subdivision regulations, which frankly are pretty bad because they're old. But we did an amendment because it had been for many, many years where the final decision for subdivision plats was at the city council level. There are still a lot of cities that still do it that way. Because the city councils do have the ability to require that those subdivision plat applications be heard by the city council by ordinance, and the local government code provides that authority. But the primary authority, absent the city council making a decision that deciding they want to hear the final, plat, it's the planning commission that still has that final authority. And of course, there are times when you get to exercise other authority that the planning commission, the city council may from time to time confer upon a planning and zoning commission. It's not unusual, for example, to have a planning and zoning commission sit as a sign board or as a landscape, or tree committee or something like along those lines.
We're very serious about that. Don't joke about the tree committee.
No, and in other cities where they still have raw land and lots of trees, I can tell you how serious it can get. And so it's but occasionally city councils will confer and maybe have you serve as rather than setting up a wholly separate board to handle matters that may only happen once or twice every 3 years, for example, they just go ahead and confer that power onto the Planning and Zoning Commission. So what's our process? Well, again, there is a technical procedural process we have to go through and when hearing a zoning case. Basically, every zoning case must have 2 public hearings. The first one is a public hearing held at the Planning and Zoning Commission, and it requires that a 10-day notice be mailed to those who are on the city tax rolls. And I say that with a little bit of emphasis because cities that have, if you have a zoning case that's adjacent to your city limits, inside your city limits, but maybe adjacent to the city limits line, those people who are on property outside the city limits are not entitled to zoning case notices because the law statute reads it's only for those who are on the city tax rolls. So if you're not owning city property within the city, obviously that property's not on the city tax rolls. So who gets the notice? Well, everybody within the boundaries of the area being rezoned. That's the subject to the amendment, as well as those who own property within the 200-foot perimeter outside of the boundary. So depending on when that, depending on the nature of that property, the size of the property, whether the property inside or outside has been developed already, that can be a substantial number. That could be as many as 3 notices, 2 notices. It could be as many as several hundred. Condominium units, for example. What's the one on, it's not Alpha, it's up at Cambridge, over on the east side. Is it Cambridge, Coventry? Cambridge Crossing. Okay. Thought I remembered that name right. Cambridge Crossing. Anytime there's a zoning notice that might impact Cambridge Crossing, for example, because by law and by property, real property rights, owners of condominiums own a fraction of all the common areas of the property within a zoning district or within the condo regime itself. And because they have actually ownership, title record ownership of a small fraction of the common areas, if you have a common area that gets into that 200 square feet, you have to notify everybody in that owns property in that condo regime. Because people who own property within 200 feet, it doesn't matter what size of an interest it is, have to be notified of the adjacent zoning change. It's kind of tricky. The notice to the city for public hearing at city council requires 15-day notice in the newspaper. So it does not require property owner notice. The city council can only act on a zoning case after it's received its report from the commission. So if the commission doesn't have a report, and now a report may be no recommendation, but if you've not taken some action on a zoning case following the public hearing that's held at the Planning and Zoning Commission, the city council cannot act on that case. It must have a recommendation or report from the Planning and Zoning Commission. So if, for example, and this happens frequently, if we over-anticipate on occasion a case going specifically to the city council, and we've already provided the public hearing notice in the newspaper for a specific council date, and because of the particular case, the Planning and Zoning Commission decides, well, we're not ready to vote on it at this meeting after we've heard the public hearing. And in fact, because of discussions that's occurred, there may be some additional changes that need to be made to the proposed regulations that are going to be recommended. We're going to act to defer action until our next meeting, or maybe 2 meetings from now. Well, what that does, of course, means it basically keeps the council from hearing the case, because they can't hear the case, take any action on it, until you all have sent the report. So you are a very important, process here. As far as hearing the case and making and the part of the process.
What is our newspaper of record?
Dallas Morning News.
Yeah, morning news. Yeah.
Have we ever done that? For you that are sitting on here, have we delayed that I can remember one time.
Yes, so in most common example would be applicant who either wasn't ready with certain final elements of the drawing, or say at the meeting, as Kevin was suggesting, certain recommendations were made by commission where the applicant had to kind of go back to their whole group and make a decision before they could say yes or no at the meeting. Those are the cases where we have seen the case being pushed.
Not all the meetings, yeah.
Yeah, one of the things we've tried to do over the last several years, for example, is we've made a real effort to get applicants, and I commend staff for doing this, push applicants to get everything in line and ready to go at least, 2, 3, maybe as much as a month before they anticipate to be on the hearing. Partly because I personally, as a city attorney, it's my philosophy and that the Planning and Zoning Commission, in making its recommendation, is actually making its recommendation on the actual proposed regulations that would be going forward in an ordinance. Which means, of course, that I've got to get involved, or Pete's got to get involved, but primarily I've got to get involved in actually drafting the text regulations so that you can see them in the agenda packet when you consider it at the meeting. That's really my ultimate preference. Because frankly, and I know other cities don't do it that way. I know other large cities that don't do it that way. They have their planning commission, they have their hearing, and then they may go and develop, and they may vote, but they won't bring it back. They push it on to the city council solely on a staff report. Well, the staff report, no offense to the planners in the room, but they don't write their planning staff reports in the same manner as I write an ordinance in most instances. And it's a different type of style, it's a different type of, many times it's a lot more detailed in the way it's worded or organized. You may have the substance, but you may not have the actual ordinance and how it will read. And so, my preference is for y'all to actually see, if not the whole ordinance, at least see the body of the regulations that are proposed to go forward. That way you really know what you're voting on, okay? And you also have an opportunity to review the language in that proposed regulations prior to voting on them, and be able to have an opportunity to ask questions about, what those regulations say, what they mean, in addition to, supplementing the staff report. So, to that extent, we really push. But occasionally, it's sometimes like pulling teeth to get an applicant to get stuff to staff. And they're going to be absolutely insistent on going at a particular meeting because, and usually 8 times out of 10 it's because somebody's got a real estate closing pending. And they need that zoning approved. I mean, of course, my philosophy is, your emergency is not our crisis, kind of deal. And, if they don't get the stuff to staff and staff can't prepare a good, valid report, if it's mush when it comes to y'all, and you decide it's mush and you need it to be cooked a little more and figured out, you may decide you want to defer it until the applicant gets their act together and gets everything the staff needs to get you a good, solid recommendation and report. So, long story to get to, have we done that before? Yes. Because I'm also not a big fan, if there's changes to be made on a site plan because of certain changes that maybe the commission recommends, I'm not a big fan of having either the commission or the city council ultimately vote on something they've never seen. I really would prefer that, if it's a text correction or something like that, that's one thing. But if it's, if it's more detailed than that, if it's moving things around on a plan, changing area, sizes of locations of open space areas, for example, stuff like that you want to see. My personal philosophy, and I think Sarupa's and her staff's is too, we want you to be able to see that, feel it, touch it before you vote on it.
So have it come back.
Have it come
again,
back.
And then, okay.
Yes.
Got it.
Yeah.
And as a practice, just procedurally, just so that it does not affect the calendar, I think what Kevin was also referring to is we ideally do not put or plan on putting an item that P and Z is scheduled to hear on the immediately following council. And that's also to prevent
Right.
a situation like this. We always plan to schedule it one meeting after. Also, one thing we really kind of dig our heels in with the applicants is that I always tell, and I have been told by my predecessors, is that we do not send notices out till the plans are really buttoned up. And that's to prevent us from that costly step of re-noticing, because more likely than what we see is there are a lot more notices than like less than 10
Yeah.
that would go out, and you don't want to send one set of notices, one hearing being publicized, and then come back and do another set of notices.
Because you have the tendency to create confusion with the public if you do that, as far as when they have to show up, and particularly if they've got a particular interest in the case. If it happens to be a residential rezoning that ends up with, a lot of, as you're aware, you may do a 200-foot, notice in a residential rezoning or near adjacent to residential, and you may only touch 15 homes. But if those 15 owners are plugged into an HOA that represents 200 homes, you can be darn sure that in many instances, you're going to have at least 100 of them in some cases, want to show up at your meeting, even though a fraction of them are only touched by the 200 foot. So, and goodness knows I've seen that happen a lot. One other thing about the 200-foot notice is very key, and it doesn't happen here often, but it does happen, is if the owners of 20% of the area of the property within the area being rezoned, or 20% of the area of the property within the 200-foot parameter. Now, it's not 20% of the owners. It's owners representing 20% of the property area, okay? So if you've got one owner that owns a substantial amount of that 200-foot buffer area, it may only take one owner protesting, submitting a written protest to trigger what's required to approve it by the city council, and that would be a 3/4 vote. And it's not a 3/4 vote of those present, it's 3/4 vote of the council. So it would require a minimum of 4 votes in favor of a zoning request if they hit that 20%, either within the area being rezoned or the area outside of being rezoned. There's a procedure for which that written protest must follow that's set out in the comprehensive zoning ordinance. And it has to be in writing, and it actually has to be the owners of the property. Tenants don't count. So if it's a multifamily, if it's an apartment complex that's adjacent, that's within that 200 feet, if the ownership doesn't show up, it doesn't matter what, the fact that half of the tenants show up won't count towards the 20% rule in this case. So
Is that a state regulation or a city?
that's state. That's part of state law.
And our zoning also adopted.
Yeah, and it's set out in our zoning ordinance as well, but it doesn't have to be, but it is. Now, some cities, many cities will go one step further. And Farmers Branch has not adopted this rule, but in many cities, and the local government code provides for this, a city council can include in your zoning ordinance a requirement that if the Planning and Zoning Commission makes a negative recommendation with respect to a case, that same supermajority rule applies. Farmers Branch does not have that rule.
Right. Roger.
Okay. One thing about zoning amendments. Zoning is a legislative act. It is discretionary. No person is entitled to an amendment to zoning. No one is entitled to amendment to zoning. It is totally discretionary. And because it's discretionary, there's no reason you have to explain why you voted one way or another on a particular zoning case. Now, you may wish to, and there's nothing that says you can't, state why you voted for or against a particular case, but you're not required to. Okay. And if you impose conditions within the zoning, you got to state clearly what those conditions are, but and with some needed explanation. But typically, we recommend, either vote for it, vote for against it. And again, on zoning cases, you're making a recommendation. So I will just say, the more if you're going to impose a bunch of conditions, then it may very well be the conditions need to be part of the regulations. Now, there may be some conditions that you can and can't, that you may not be able to do, and we'll touch on that a little bit later. Here's one that we often forget, but fortunately your staff is good about focusing on the comprehensive plan. And of course, as we all know, we're going through a comp plan rewrite right now. And so this will change up some as Farmers Branch with Mercer Crossing and everything to the west largely, nearing build out. Once you've hit build out, basically at that point, your comprehensive plans only primarily will serve to direct redevelopment in older areas of the city. For example, on the east side, where a lot of the old warehouse area on the east side is beginning to kind of convert to other types of uses and not so much for warehouse anymore. Or maybe different types of warehousing than what was originally developed back in the 60s and 70s. So, this will dictate some of that. But your zoning ordinance must comply with your comprehensive plan. Now, keep in mind, just a reminder, the comprehensive plan itself is not a zoning regulation. The comprehensive plan is a guidebook, if you will, or a guiding document that basically tells you kind of what should and shouldn't go in different areas of the city, what the types of general regulations ought to be. But for the most part, it's, but your zoning regulations, when considering adopting any amendments, must conform to your comprehensive plan. Okay. We'll touch a little bit on the types of uses. And just, again, these are some things you probably know and, isn't any great secrets. Permitted uses, or sometimes euphemistically called uses by right, are those that are actually within the use chart for the various zoning districts in this comprehensive zoning ordinance, that basically, without any additional regulations, having to be adopted, all they have to do is go into a particular zoning district that allows that use and comply with the regulations for that zoning district that are in the CZO, and they can go in without, go in and start using, develop property and use for that particular right, for that particular purpose, I should say. Specific use permits, again, and the way I've kind of, again, I don't, there may be a particular definition that professional planners have in their APA, documents and books. But the way I kind of understand specific use permits as a lay person who's drafted many is basically a specific use permit is or specific use. Let me say this. A use that requires a specific use permit to go into a particular zoning district is one that would normally be okay, except it needs a few more tweaks on the regulations to actually make it fit into that zoning district. Because again, part of the philosophy of zoning is to allow adjacent, compatible uses, not necessarily, uniform uses, but compatible uses. uses that don't impact negatively each other as they developed and are used. So specific use permit, specific uses that require the specific use permit don't necessarily fit a particular zoning district unless you add some additional uses. So it may be a little bit more intense use that maybe what you want to do is you want to add some additional screening, or you may have to change the setbacks a little bit so it's a little further away from property lines. It may need some additional parking, have to meet additional off-street parking requirements in order to go into a particular zoning district that may has a lesser requirement for off-street parking. So that's really what a specific use permit is intended to do, is allow those types of uses that otherwise wouldn't be compatible, I say it that way, otherwise would not be compatible without the additional regulations. Okay. Again, because an SUP is a zoning amendment, nobody's entitled to get an SUP for the use for their property. It's just like any other kind of adoption zoning regulation. It is a legislative act. Now, in our use chart, we also have identified a few what we call temporary uses. That's usually those don't come before the Planning and Zoning Commission. They are usually administratively approved, but they're short-term type of uses that have a specific set of regulations in the CZO themselves that, Christmas tree lots, stuff like that. That's typically, Christmas tree lots, certain types of, entertainment, events, there might be a temporary use. I mean, those kinds of things, don't necessarily plug into all districts, but they can be handled administratively because usually we have a fairly detailed set of special regulations that go with those kind of temporary uses. But we identify in the use chart what zoning districts what zoning districts those temporary uses can go in.
A quick question on the SUP.
Yeah.
So let's say you had 3 exceptions that were proposed, and the commission says okay to 2 but not to 1. Is it then the applicant's decision whether they want to still go forward since that one wasn't approved, they're going to have to change based on the fact that it wasn't approved? They have to go back and just decide whether they still want to go forward? Is that what happens?
Yeah, I mean, if your recommendation is to grant an SUP, well, let me see if I can rephrase that and make sure I understand the question. If there's, say, 3 particular
Exception.
modifying regulations that need to be adopted, or that want to be adopted, and you're okay with 2 of those, but you're not okay with the
Right.
third.
Yeah.
Well, basically, what you could do is you can recommend approval, but the recommendation would only include the 2. So if, say if they're doing an SUP that wants to have a particular kind of use that, I guess, that they want a particular kind of use, and maybe they have to have, maybe they're wanting X parking, and you're saying, no, we want X plus parking. Let's just say that. And they say, that's kind of a negative recommendation as far as that element that they're requesting. Your report can say, no, we're going to require X plus parking. And then they can go to the city council with the recommendation you all have provided. It's still a positive recommendation, but it's a positive recommendation with that additional condition.
I think,
And decide, it sometimes can get a little confusing. Am I?
Yeah, I mean, I
Is
just
that kind of
wanna-
the question you're asking? I just
Yeah, I
want to
mean,
make
if
sure.
we said, okay, sure, you can have 2, but not that one, we don't agree with that third one.
Yeah.
So then that still just goes forward to the city council, I guess. Do they have to then stop and decide whether they still want to proceed based on the fact that that third one wasn't approved? Or?
Yeah, and because what they will do is they'll present their case to city council, the staff will present the case and the recommendation of the commission on that case, and then it's ultimately up to the city council to decide, do they want to go with the P&Z recommendation? And if they decide they can't live without that third one, then they've got the opportunity to withdraw the application.
I think another kind of a example that might help explain this. So as Kevin was explaining why an SUP is sometimes requested, and it's called different things in different zoning ordinances and communities. Sometimes it's a conditional use
Conditional use
permit,
permit,
sometimes
yeah.
it's a specific use permit. It's, as he explained, a particular land use that does not fit like right in, like it's not a obvious, yes, that's a good neighboring land use in that zoning district. But if they give you more detail and if you can provide some conditions, then maybe it can be a good neighbor. That's the kind of the underlying premise of a SUP. The example I wanted to point out is, and I think it would be fresh in our memory, last year or the year before, we did some amendments for event center, banquet hall SUPs, where there were several conditions usually were applied to banquet hall as a land use. Because going back to his previous slide, as we recall, for any zoning regulations, there are some basic tenets, whether it's congestion on streets, whether it's safety from fire, panic, other dangers, you said health and general welfare. So we have to base our conditions on those grounds. So same with this banquet hall use. So there are traffic concerns. It's going to add quite a few number of people. There are some safety concerns. So usually those land uses, a common condition is you have to hire off-duty police officers. There are hours of operation restrictions. So in those cases, the way staff would present the application to the commission would ideally be, you'd kind of have a list of, okay, these are the conditions that we are recommending. And usually the applicant would, in many cases, be either on board with those conditions, and that's how they would be brought in front of you. Now, if, say, at the meeting during the discussion, some condition was found by the commission that maybe it has to be enhanced or changed, and that's when, if the applicant is not comfortable in going, like, say, rather than hiring 2 peace officers, the commission is saying maybe the scale of the event or the number of occupants, that facility might require more. Would you be looking at hiring more police officers based on the number of attendees? And it's a real example. That's the adoption we did 2 years back. So on those cases, yes, there are some things that has to be discussed on those grounds. And if the applicant at that point is comfortable with those changes, we present that changed version of the ordinance to council. If they're not comfortable, then as Kevin mentioned, then we can also present that to council, because given that P&Z's recommendation was overall positive, recommendation for approval, not denial. So we present that this was the P&Z's recommendation, however, there was the concern with X, Y, Z. And at that time, council as the ultimate decision-making body would make a decision. Was that where
Yes.
you were going with the condition?
Yeah, and it's not uncommon that if, once it goes to the city council, that if it looks like, to the applicant that they're counting noses and they don't see they've got the votes to get what they want, it's not uncommon for them to go ahead and pull the application. Because sometimes it's better to pull the application than to get a zoning ordinance that they actually don't want. And just kind of start from scratch.
And the other reason for that, also our zoning ordinance has a provision that if a zoning application is denied,
Right.
they cannot come back within a year.
Right.
So that also sometimes, I think,
Yeah.
deters.
And you can have, I can't remember, I'm trying to remember if we have the with prejudice or without prejudice distinction. I can't remember. I know a lot of cities will have a provision that if they are denied without prejudice, they can actually come back within a certain period of time. Otherwise, they've got to come back. They can come back, but they've got to make a substantial change to the application. So they can have another zoning case affecting the same property, but there must be a substantial change in the application. So it's not exactly the same application, that we saw that was denied. So.
So let's say on a house, and we've done this here, they made an application for an SUP to change, I remember a couple of things. One wanted a bathroom in their garage area and whatever. If we do that, that doesn't automatically say somebody else can do that. They have to apply every time, correct?
Correct.
For an SUP.
Right. Because, legislation, again, because it's a legislative procedure, you look at each case on its own merits, and based on its own fact situation. So just because somebody gets to convert their garage to a secondary dwelling, above the garage, doesn't mean everybody gets to, because, depending on the size of the property, the proximity to property lines, all those kinds of factors that go into making that decision may not be exactly the same. Now, that doesn't mean you won't necessarily look back at the prior case and say, hey, this was similar, is there any reason to deny this one because we saw? You can certainly do that, but you're not mandated to.
And also, just like specific use permit in any case or any zoning, it's tied to the property. So one person getting a SUP does not really qualify anyone else getting that same SUP. It's only for that property.
Yeah. Keep in mind, it's land use. It's based on land use and the characteristics of the land and surrounding land. It has nothing to do with personalities.
Yeah, but I can see in a home, well, they did it, well, we can too, and we don't have to go ask because it's already been cleared. Is
Well,
what my thought
right.
process was.
Well, I understand, and that's just unfortunate, but, that's also unfortunately, I've learned over my 3 decades of doing municipal law, not a lot of people know how cities work. Unfortunately, the level of which civics education in this country has, diminished greatly over the decades, and local government, unfortunately, which touches us the most, is the one we often know the least about.
Certainly covered
Sadly.
specific use permits in my high school government class.
Yeah, well, but the basics of city ordinance, even just basic of city ordinances, where your water come from, how it gets there, who pays for it.
We all know a lot more about ERCOT, that's for dang sure.
Understood. But it's, and that's one thing I have learned over the years is, how little we as citizens, and I say that in a global perspective, know so little about the government that touches us the most, and that's local government. And it's sad a lot of times. And zoning, of course, is just part of that. All right. Let's talk a little bit about planned developments real quick. Basically, what a planned development is it's sort of an overlay zoning. Usually has its tied to a specific base zoning, although you can have what a fully customized planned development that basically is a kind of an all-comprehensive, all-inclusive type of district. Many times it's used in order to kind of like an SUP, but it's usually more for designing, mixed uses. They were, I think, conceptually, planned developments were intended to be for much larger mixed-use developments in order to, be able to mix in your commercial, your residential, your retail, and even to some extent your industrial. Within larger tracts of land, so that you can kind of design them all together. They all kind of fit together, kind of create your canvas and paint your different areas on your canvas, and that's how it is. I will tell you by experience that has now almost become the norm as opposed to the exception in the way cities do zoning. Because in almost all instances, particularly in cities that are largely built out, you need to customize zoning regulations in an effort to create a quality development. And so we find that cities are doing planned developments on smaller and smaller and smaller tracts, almost to the point that they're virtually the same thing as an SUP in many instances. Although they go through, because it goes through the same procedures, as far as zoning, as far as approval procedures, it goes through the exact same procedures as an SUP. Because it's just like anything else, it's a zoning amendment. And so it has to go through that whole 2 public hearing, P&Z, city council process. But, you know, and of course, now we're seeing different kinds of plan developments. If you know, there's now this, what's called the form-based codes, which are fairly self-contained. You know, Mercer Crossing is a form-based code. We've got several different form-based codes. We've got
Started with
several.
the station area and
Yeah,
then.
station area is form-based code. And of course, we totally upended when we went from the commercial retail type multifamily development scheme for Mercer Crossing. When we went to residential, we totally upended, the form-based code that had been adopted in the late 80s for Mercer Crossing. So, so even those can be amended and redone completely if necessary. If the scheme for planning for a particular area, dictates it, and market dictates it, and local and community, desire dictates it. So, but they're primarily used to promote high-quality residential and/or non-residential development. And authorized uses, and this is where the other thing comes in with PDs. Within a PD, you can actually add uses that wouldn't otherwise be in the existing base zoning. And we do that frequently. And you may also prohibit uses within a particular base zoning. For example, I'm working on a zoning ordinance right now in another city where we've got light industrial, mixed, medium industrial going on, but we've got a list of, the base zoning is going to be light industrial, but they've added medium industrial uses to the mix. But we've also got a list of prohibited uses so this whole list of prohibited uses can't be developed on this particular property in order to prevent some of the more high-intense medium industrial uses from being developed on it. And so you can do those kinds of things in a plan development. And basically, it just allows a lot of flexibility, in how you design your development. It requires a lot more work, a lot more effort. That's why it drives us crazy, drives me crazy, drives the planning staff crazy. When somebody's trying to come in with a large plan development and they've barely scratched the site plan, the concept plan on the back of a napkin. Trust me, I've seen those, and I know your planning staff has too. And it's because you need more details than that. But it's a good tool. It can be a good tool when used properly for purposes of development within your city, to make sure you've got more of a planned community as opposed to just a hodgepodge of a group of, developers kind of, hopscotching around and doing their own little thing within, a particular area of your city. Again, as I said, it goes through this. You go through the same process as for use. You can have multiple. Mercer Crossing is an example. You can have multiple sub-districts within a planned development district too. So each sub-district may have its own variation of regulations within the overall set of regulations within a planned development district. Any more questions about PDs at this point? Okay, I'm trying to watch my time. Let's talk a little bit about detailed site plans real quick. Typically, because developers don't want to spend the level of money, the amount of money they need at the initial zoning entitlement stage to give you the level of detail that you need for purposes of determining what it is they're going to develop. Many planned development ordinances will only have a set of regulations and a concept plan. A concept plan is more of I won't say a 30,000 level, but maybe a 15,000 foot level sketch of the overall outlay of the proposed development. it'll typically show, may show some of the, where the zoning, different zoning uses will be, or base zoning that they're going to utilize for different areas might be. It'll show kind of the general layout of roadways and other access points and other, maybe certain types of amenities, open space, those kinds of things. What the Farmers Branch CZO does is it allows that in adoption of the initial plan development ordinance. However, it goes on, as you know, to require that a detailed site plan be adopted for the area within a plan development district before any building permits can be issued for that property. That detailed site plan, which we also call, which is actually in the CZO called a comprehensive site plan, but we have over the years called it a detailed site plan, is basically, again, it does not require a public hearing, but it still has to come through Planning and Zoning Commission for recommendation, for review and recommendation, and go to City Council for approval. It's got to be consistent with must contain all these elements that you see listed in that third paragraph, and I won't spend time reading it to you, because I'm sure there will probably be, if you don't already have it, we can make the slideshow available to you for your reading pleasure on your own time. And, everything that goes into the detailed site plan that you often see that staff requires will be in the detailed site plan. Again, it has to be adopted before any building permits for that property can be issued. It's got to be consistent with the PD regulations and the concept plan. Now, typically, we'll have some language in the PD ordinance that says you can, without having to come back and amend the concept plan itself, you can do some variations of, the detailed site plan can vary some from the concept plan. So we'll put that language actually in the PD ordinance itself. Usually, as long, location of roadways, for example, is typically one. Roadways get changed as long as they maintain the same kind of circulation pattern that's set out in the concept plan. There can be some variations from the concept plan. It's naturally going to add more details, areas for screening, areas for where intersections of roadways are, areas for where different uses are going to be if need to be called out. It's going to typically add your building elevations. Now, as you know, we can't dictate building materials anymore, but we can at least dictate what they look like. Now, they may put up, if they want to paint a whole bunch of stucco and make it look like what that says when we were kind of anticipating brick, okay, that's fine. As long as they make it look what's in the picture, okay, they've complied. But at least you know what you're going to get as far as what something looks like. You can't add uses. You can't prohibit uses. You can't change the allowable or prohibited uses from the underlying PD. So, because that's not what a detailed site plan is for. Those have already been granted through the PD ordinance. So as long as your detailed site plan is consistent with the PD ordinance itself and doesn't conflict with it, it's much like a plat, and I'll talk about plats here in a minute. You pretty much have to approve it. They're entitled to it. They're entitled to a detailed site plan. You can't just, and this is kind of a running debate that city attorneys have as far as detailed site plans for zoning. And because it doesn't require a public hearing, it technically doesn't constitute a zoning amendment. It's really more of a permit type of process, which is administrative and ministerial. And as long as it contains all the elements that it's required to contain, and as long as it's consistent with the underlying zoning PD ordinance, then it should be approved. There's very rarely should there be a reason to turn down a detailed site plan, as long as it complies with everything. Any questions about that? Because I'm about to move to plats real quick. All right. Subdivision plats. With a couple of exceptions, if you divide land, if you own a tract of land and you divide, and you want to sell off a piece of it to somebody else, you got to get a plat. Must. If you're in the city or in a city's ETJ where the city has exercised its jurisdiction to control platting within its extraterritorial jurisdiction, which most cities have done, then you must get approval of a plat. One thing that I don't have in my slideshow is if a property that has been subdivided and not obtained a plat under state law, cities are basically prohibited and may withhold all utilities. In fact, utility companies are supposed to hold utilities. Now, I will tell you, Encore and Atmos, they rarely check to see if property's been properly platted before they allow electric. So if it's unless we just happen to have to come through the city permitting department in order to make sure that the plat is done, you can withhold utilities and you can withhold building permits because building permits have to be on properly, buildings permits cannot be issued except on properly platted property. Okay. Now, I won't say that people don't get away with that on occasion, but that's the rule. There is an exception, and the exception is if you've got a large tract and once you subdivided the two parcels, or however many parcel it is, are all 5 acres or larger, and they have access. Now, I'll be honest with you, state law doesn't define what it means for them to have access. So I've occasionally had to say, as long as they've got a permanent dedicated easement that gives access to a public roadway, then it has access. But, don't like that because sometimes those subdivisions are done, here's the road, here's the north end of the property, and they split it between they run an east-west property line, so that rear property is effectively not fronting on a public roadway. But as long as they've got a permanent easement that they can enforce that gets them to that roadway, sometimes we have to let that one go. But as a general rule, anything that's got to be subdivided, that is subdivided by meets and bounds description and sold off before they can sell it, legally they've got to obtain a plat. Cities can also add exceptions to the platting requirement. Some cities will add things like if you've got a family that's inherited property and they have a court order that subdivides that property amongst the family members because they inherited it and they're splitting it out, they can, some cities will actually not require plats in that instance. I've begun suggesting on occasion that we don't require plats when the state, or the county comes along and takes a piece of your property for a government purpose, such as a street, right-of-way or the I-35 project. Technically, that's a subdivision. When that property is acquired, say out here from property acquired by the state for the I-35 project, technically that's a subdivision. Now we've not been making people replat their property in those instances, but technically we could. I've generally of the opinion we just need to make that an exception. Honestly, we don't have that exception written into our subdivision ordinance. And as I noted earlier, the planning commissions are the primary initial authority for plats, and the councils can delegate to themselves the right to have the final say in plats, but that's not the case here anymore. And of course, city council may delegate to city staff approval of certain plats. As if you've heard the term minor plat, we'll talk a little bit about that in a second. And we'll talk about different kind of plats here in a second. Okay, plat approvals. Plat approvals. Here's the thing. unlike zoning, plats are like permits. If it complies with the regulations, you must approve it. If the glove fits, you must acquit, okay? I mean, that's just the way it works. For anybody who's old enough to know that reference. Or in that case, it was if the glove doesn't fit, you must acquit. You've got to approve it. And and here's the other little trick under state law. You have to approve it within 30 days of in what we've defined as of an administratively complete application. Now, I'll be honest with you, I'll just tell you now that administrative complete application process has been under attack the last 2 legislative sessions, because what basically it requires applicants to do is get all of their engineering done, make sure the plat drawing itself has been completely edited and is correct in accordance with all the city's regulations. Has everything on it it must have on it, all the easements, all the survey points, all the calls for the different lots, lot numbers, names, street names, all that kind of stuff that goes on a plat. Which, if you knew what your planning staff and your engineering staffs go through in reviewing plat applications, and the poor workmanship, I will be nice and gentle in what in referring to it, the poor workmanship that often comes in on plats, and the number of times you have to go back and forth with an applicant or applicant's engineer or surveyor, whoever's preparing the plat. It takes time. It takes time. And without that, but the legislature says, and has said for years, you've got 30 days from the time you get an application. Well, we've, under state law, in taking advantage of admittedly a loophole, we've defined what it means to have a complete application. That complete application means you got to have everything correct. Once it's correct, then the 30-day clock starts, and they've paid their application fee. Got to get the fee. Yes, ma'am. Yeah.
So if there is, in case of this, a Highway 35, if a plat is modified through an acquisition of the land for the expansion of the highway.
Right.
And we're not telling the current plat, because it's been modified due to the expansion, we're not requiring them to create another plat?
No.
Because of the difference? So if they change something in their plat, let's say from food to something else, with that?
Well, now you're getting into zoning
Zoning.
there. Now, I will tell you what can happen is it can impact the uses on the property. And that's something, and that's, of course, that gets into a whole separate part and a whole separate board known as the ZBA.
Okay, I was just trying to
that handles that stuff.
Well, thank you.
Yeah, no, there is an outlet for that, from a zoning standpoint. If there's anything that should get a variance from the ZBA, it would be somebody who has a particular zoning use that because they go beyond, under the required regulations because of a government acquisition of their property, such as the I-35 project. That is, if there's anything that's a sound basis for a zoning variance, that would be one of them. But that more affects the zoning and not so much the platting itself, the subdivision part.
Even if it's like changing the access to that, the design or the width and distance of.
Yeah, that ends up being
the plat?
more of a development regulation issue and not necessarily the actual subdivision of the land boundaries itself. This really more affects the land boundaries, dedication of roadways, location of utilities, the real nuts and bolts of the land. You're getting a little bit more into the land use, the zoning aspect of the use of that property that's affected by that acquisition.
And
Yeah.
if I may add, Kevin, it's not so much even the use part of it. What more common is to happen is like the setback. If a property is fronting on 35 and due to the
Right.
highway expansion, say a portion of the frontage was taken. So that would mean that if they had a required front setback of 30 feet, now they don't have the 30 feet setback because portion of that setback was taken. Now, in our zoning ordinance, we have a section called non-conforming uses and structures and sites. So there is a provision in there where it actually protects the property owners because it says, if due to a government action, a property or either a use or a site so there are three different categories. Either your building is non-conforming or your site is non-conforming, or like parking, say it took away a row of parking. Those are going to be considered legally non-conforming. So the site can continue to operate if it can
Right.
with that same use, with less parking or a less setback, because that non-conformity was not caused by the property owner, it was caused by the government action.
Fair enough.
Yeah.
Thank you.
Okay. With some changes in in state law here, past couple sessions, it is now a requirement that, cities can now, or planning commissions can now approve a plat conditionally. And what that means is basically it's not approving it and, or it's approving it, but you can't record it and sign it until they've met certain conditions. Typically, there's going to be things like it's got missing signatures, or it's got some typos, or something like that. Or they can deny it. However, unlike your zoning, you have to detail every reason you're denying it. And not only do you have to detail it, you have to cite the specific regulation as that for which it doesn't conform. So in other words, you've got to give a solid reason based on either state law or your subdivision regulations or zoning regulation as to why you're denying a plat or only conditionally approving it. If you fail to do that, then it's, in a very short time, and there's some deadlines, then the plat gets approved. So that's why being able through the legislature contain this, retain this administrative completeness process is very important. Again, well, I don't have time to get into my soapbox about the state legislature and getting into local government planning process, so I'll leave it at that. But I will say, there's some bad legislation that unfortunately comes about because of a couple of bad actors while the rest of us are trying to do it right and cooperate with developers, okay? I'll leave it at that. All right. Types of plats, preliminary plats. We've actually done away with preliminary plats because frankly, again, we don't have that many large piece of property left in Farmers Branch that really warrants doing a preliminary plat. But, preliminary plats are large plats. They're preliminary because they don't have the level of detail for a final plat, but they kind of give a general layout for a large tract that then you come back and piecemeal your final plats as far as that goes. Final plats, again, has all the details and the layouts of streets and whatnot. Replatting. Replats are tied to property that's already been platted. You're just rearranging, either re-subdividing larger tracts that have already been platted, or you may be redesigning a platted area, doing different kind of lot layouts. The minor plat is one that can be administratively approved. 4 or fewer lots, no new streets, no new dedication, utility extensions. So you can do up to 4 lots of a minor plat and have it administratively approved. Mending plats are another kind of plat that basically can be administratively approved. It basically is just fixing stuff, Or, in this case, actually amending plats can be used to remove lot lines and to combine lots and that can be done administratively. You can move a lot line between 2 lots and do that as an amending plat, but you cannot add lot lines and create new lots with an amending plat. That would be a replat. Okay. All right. Anything else about plats? I know that's pretty quick, but again, Most of the work is done well ahead of you, and frankly, I've got some planning commissions now that are putting their plats on consent agendas. Because frankly, again, if it complies, you got to approve it. So there's not a whole lot to discuss on a plat, on a final plat. All right. Quickly, we'll go, so that's all kind of the nuts and bolts part. The rest of this is just going to be kind of meeting as I mentioned at the very beginning, a few rules and words of wisdom, I will say. I won't say they're hard, fast rules. I will say words of wisdom, even though we title it golden rules for boards and commissions. And this applies to pretty much everybody. Of course, your chairman's the one who calls the meeting to order, presides, rules of procedures, make sure they're followed, works to maintain the dignity of the meeting, et cetera, et cetera. Confines the discussion to the topic on the agenda. I throw that in there because if I have anything to say about Open Meetings Act reminders, that's the point right there. I'm going to mention the Open Meetings Act. Because we have a tendency sometimes to start talking about stuff that has nothing to do with the case. In fact, it doesn't have anything to do with anything on the agenda. Somehow we'll start, as we, if you've seen, I think isn't it the movie Up? Where you have the dog, where they say, squirrel, Yeah, we tend to do a little squirrel action once we start talking about, running down rabbit trails with certain topics, and all of a sudden we're totally off the agenda topic that's been posted. And we're having a substantive discussion about an agenda about a topic that's not posted. Part of the role of the chairperson is to bring that discussion back, and if necessary, totally cut it off and make sure, hey, let's get back to what's on the agenda, because we're running afoul. We may be running afoul of the Open Meetings Act here. So we just have to be careful about that. Of course, regulating talk. Bickering or, having any bickering or exchanges of personal opinions should be avoided. Keep the topic on the case. Keep the discussion on the elements of the case. Is it a good land use? Is it bad land use? Is it compatible, not compatible? Does it comply with the comprehensive plan? Does it not? Are there different things we should do to make this, if we're going to approve it, here's some additional conditions I think I would prefer, but if it's a PD and the PD is already approved and it's already got specific uses that are allowed, arguing and discussing those particular uses, whether they're good or bad, is kind of moot point, because that's not what you're there to change. Unless it is requesting a particular, if it's requesting a change to the particular use that you don't care for, okay. But, let's keep it on the topic of the case itself. Of course, avoiding personal attacks. I can't tell you the number of times I've cringed at comments about developers, and sometimes particular developers, and their personal comments about particular developers. Had nothing to do with the case whatsoever. Please don't ever go down that hole. Keep your comments framed in objective terms. Again, personal likes and dislikes, I think, I can kind of hedge a little bit on that, but don't get into an argument, don't get into banter, particularly with an applicant or even a citizen about that. And make sure everybody's treated fairly and similarly. That's, again, I think if you look like you're favoring particular people, particularly if you're favoring particular people consistently, it's going to be known. And particularly when you televise all your meetings, the public knows more than just the folks who are in the room. The purpose of a public hearing is to allow the presentation of evidence and presentation of the case. hear both sides of it. Allow people to hear both sides. I'll tell you one thing, and I kind of admonish my chair on this. Refresh my memory. Are we at P&Z? Are we doing the speaker forms like we do? Okay, at council. Okay,
Well, not the prior registration, so they can fill out a speaker
Okay.
card downstairs.
What I suggest is don't sort them by the people who are for or against. Don't call them up by say, all those who are for it, or all those who are against it, come, start the names. Just take them in the order that they come and let them tell you whether they're for or against. Because otherwise, there may be a tendency to show a little bit of bias, because what's going to happen is, and on this next one, numbers don't always count. There may be a very good case that's a very good reason to approve it. One thing if you've been in this long enough, only the people who are against it, and it's usually the same handful of people in many instances, will always come to a meeting and be against something, where there may be thousands out there who would be benefiting from a particular zone change, who don't show up to me, because typically, it's our nature, only the people who are against something are the ones that show up. The people who are for it don't come out in the big numbers. I mean, that's just the nature of the beast. And so, so while you may want to go with the room, and you may feel that way, just understand you don't have to if it's a legitimately good zoning case and there's a good case for it to be approved. One thing in conducting a meeting, there's this tendency sometimes for speakers to get up and turn to the audience. Don't let that happen. I recommend. Speakers should always be, their role as a speaker and their right as a speaker is to come present evidence and testimony to you as a commission. They're not out there campaigning the people behind them. They need to be talking to you guys. So make them give you the respect that you're due, and make them direct their comments to you as the commission. Okay? And because people will do that. And they'll turn around and ask questions to everybody. I would suggest the most orderly meetings that I see on a regular basis are those where people will come up and ask questions, and sometimes they'll be rhetorical, sometimes they'll actually be asking legitimate fact questions. My recommendation is somebody be charged with writing those questions down, note whether they're directed to the developer applicant or to staff, and hold those questions until the end of the public hearing, and then go through them and work on answering them. Now, I'll tell you, the one downside of that is sometimes the answers to those questions will trigger a whole bunch of, hands going up in the back, or sometimes outbursts from the audience, okay? Because they'll now want to ask 5 more questions. So, it's up to the chairman and up to the commission whether if you've closed the public hearing at that point, whether you'll reopen the public hearing or are willing to allow folks to come back up and ask their questions. I recommend, and unless you want to be there all night, and particularly on a particularly controversial case, that you give everybody one shot, and that's their shot to give their shot at it. And that's it. When you close the public hearing, close the public hearing. Now, I'm not going to tell you don't have the discretion to do otherwise. I'm just telling you, again, words of wisdom from years of doing this.
We have a nice, statement that we read before the public
Okay.
hearing. Would you suggest restating the section of that indicates that any questions, can't be answered, but.
Well, that's under your citizens' comment. I'm talking about the public hearing
Oh, I see.
section, where you can respond. Now, I would suggest that if you're going to have an exchange with a speaker, and I'm not talking about the applicant now, I'm talking about members of the public who are attending the public hearing. If you're going to have an exchange with members of the public, what I would suggest is you limit it to clarifying questions that you're asking them to make sure you understand more what their position is or what the statement was that they made. Leave it at that. Don't get into I agree with you, I disagree with you, rah-rah. I mean, because all of a sudden now, one, you're viewed as biased. You've kind of already tipped your hand on how you're going to vote. But I think you lose some of the decorum in the meeting, and also the meeting will get extraordinarily long if you do that. Especially if you do it for some and not others. That's the other thing. Again, treat everybody fairly, treat everybody the same. Again, you're not required to give reasons on a zoning case. You're not required to give reasons on your vote. You don't have to justify yourself. You can if you want, but you're not required to. Be sure the reasons are lawful. And I'll tell you, I'll get back to the mic. I cringe every time we have an apartment zoning case that I know is controversial, because it comes out with the same, it's not even necessarily the same people, but I tell you, I hear the same thing every time. Almost every time I hear an apartment zoning case. And I'll be honest with you, sometimes the statements that are made by the public, and if you're seen, are, I'll just be honest, I'll just be frank. They're darn near discriminatory. Many times they're darn near racial. And I'm not going to, and you got to be careful of that. Now, if a member of the public says it, you can't help that. But if you sit there and nod your head, then all of a sudden, in a particular case, you may find yourselves or the city in a lawsuit on some kind of discriminatory action on a Fair Housing Act claim. So you have to be careful that you make sure what you say and your reasons are legitimate land use-based reasons, especially if you're planning on denying a case. Unfortunately, I'm having to say this more and more in my P&Z trainings. And, particularly as cities get closer to build out and you're still seeing a desire for apartment developments. So be careful. I just caution you, think before you speak in certain instances, and think before you nod heads and agree with certain people who may say something that just, frankly, a member of the public is just blatantly discriminatory. Okay, be careful. I would avoid negotiation sessions with the developer, especially long ones, in the midst of trying to get a case approved or not approved. I mean, if the case isn't ready, it's not ready. And it probably shouldn't have been on the agenda in the first place if it's so bad that we're having to sit there and negotiate, conditions on the zoning. So, and if it's to that point where there's certain things that need to be negotiated, language that needs to be worked out, especially if you don't have an attorney there at the meeting, one of the city attorneys there at the meeting, which typically you don't, then it's probably the thing to do is try to get the substance and the consensus of what the commission wants with respect to the changes, and then defer action on it, and then let the staff and possibly, somebody from our office, me, probably, sit down and work it through with the developer and come back at a later meeting, rather than spending a lot of time trying to work out language for an ordinance that they want to go forward. And now I'll tell you, developers will push to get you to do that, just that. They will push you to try to go ahead and approve the ordinance or give a recommendation to ordinance that night. I would urge you, don't feel like you got to do that. Again, their emergency, their closing date is not your problem. And that may sound anti-development, and I'm anything but. But I'm also anti-bad decisions. And I don't want you to be forced into, or feel like you're even forced into make a bad decision or an incomplete decision in making a recommendation by forcing a decision to go forward with a recommendation to city council when in fact you don't even know what all has been, needs to go forward, or like I said earlier, you haven't seen what's on the paper. So, that's it. Only 5 minutes over.
Thank you, Kevin.
Yeah,
Thank you so
yeah, if
much
there are
for
any
your
other
time.
questions, if we need to, at some point, if there's a particular topic that we want to talk about in a workshop, I now live in Grapevine and not Midlothian, so I'm actually closer. So it's easier for me to get here on Monday nights, most Monday nights, not every Monday night. So, I can be available for particular topic type workshops if we need to kind of flesh out some of the more of this type stuff.
And as we have Kevin here tonight, I just wanted to clarify one item, and it is not related to what we heard tonight, but more of open meetings,
Yes.
agenda posting.
Okay?
Correct me if I'm wrong, once the agenda is posted for a 7 o'clock meeting, as long as we don't start before 7 o'clock, we are okay. If we are delayed by 5 minutes or so, that is not a problem.
That is not a problem.
So I just wanted everyone to know, sometimes I feel like we feel rushed
Yeah.
if we are discussing something at study session, but legally, by a posted agenda, if it's posted for 7 o'clock, we cannot start before 7. But if we are going over because of our discussion at study session, we can always go after.
That's
5 or
correct.
10 minutes.
That's correct. That's not a problem. I mean, and we have, because typically we'll post this, for example, public hearing times are typically going to be posted as the same as the meeting start time. Again, Sharif is correct. As long as you don't start prior to 7 o'clock, it's okay. I've had city councils that have started, that have 7 o'clock start times that don't start meetings at 7:45 because we've been in an executive session that just had to get through and get done, and so, that's going to happen. But yeah, that works out. That's right.
Again, thank you, Kevin.
Thank
Thank
you.
you so much for
Thank you,
your
Kevin.
time.
You bet.
I'm sure it was very valuable, and if commission wants more deeper dive, I'm sure we'll be able to arrange something at a later date.
Well, that will take us now. To item A2, discuss regular agenda items.
I think the minutes are great. We should go downstairs and approve them.
Regular agenda item C1, consider approval of the September 26, 2022 Planning and Zoning Commission minutes and take appropriate action. I think I've pre-heard that no one has, is there any other comment of errors, omissions, typos?
If it was about the firehouse, you didn't record me asking about whether it had a fire engine basis or not, but somehow that seemed less
Do
than
you want your
substantive.
name in there?
Well, no, it just seemed less than substantive, but I wasn't sure if my mic was on or not.
I think staff captured the substance of the meeting, as you indicated. All right, well, that brings us back then to that concluding the regular agenda items, back to item A3, discuss agenda items for future planning and zoning commission consideration. Anyone have future items?
So I saw a zoning change sign at Brook Hollow and Valley View. Is that something, and I thought we would see it here, and then the sign's gone and we're not seeing it here. Is that something we'll see in the future?
Probably not, but the application has been withdrawn by the city.
Got it. Okay.
Good eye, Bonnie.
Yeah.
Well, there's a bunch of construction there, so I'm always going slow looking for it.
We're gonna start calling you Deadeye.
And there's always like raccoons and that,
Yeah, yeah.
because there's that creek area,
Right,
anyway.
right.
I drive there a lot, because
You know, the wildlife over there, that's how much you drive over
I see a
there.
lot of roadkill. But I do live like a block.
Yeah.
So, I mean,
All right. Well, I think with that ends our study session meeting. It is presently 7:09 PM. Do we need to reconvene downstairs? Yes?
Let's do it.
That's how it is posted.
That's the location.
Yes.
I'd like to welcome you to the City of Farmers Branch Planning and Zoning Commission meeting. It is Monday, October 17th. It is presently 7:15 p.m. And I want to thank all the commissioners for their service. We'll start with citizen comments. This agenda item provides an opportunity for citizens to address the Planning and Zoning Commission on any matter that is not posted on the agenda. Anyone wishing to address the commission should complete a citizen comments registration form and submit it to the chair prior to the start of the meeting. There is a 3-minute time limit for each citizen to speak, with a reasonable limitation on speakers on one topic or item, with a maximum of 15 total minutes on the same topic item. Anyone wishing to speak shall be courteous and cordial. The Planning and Zoning Commission is not permitted to take action on any subject raised by a speaker during citizen comments. However, the Planning and Zoning Commission may have the item placed on a future agenda for action, refer the item to the Director of Planning for further study or action, briefly state existing city policy, or provide a brief statement of factual information in response to the inquiry. Do we have any citizen comments this evening? All right, seeing none, we will move to our regular agenda items. Regular item C1, consider approval of the September 26, 2022 Planning and Zoning Commission minutes and take appropriate action.
I move to approve the minutes.
I have moved for
Well,
approval.
I would like to, this is my first meeting as an official member, so I would like to make my first motion to second the. Yes.
Thank you, Commissioner, to second. Any topic of discussion on that item? All right, seeing none, we'll move to voting. All those in favor? That is unanimous. All right, thank you. And with that brings us to adjournment. We will adjourn the meeting. It is presently 7:17 p.m. Thank you kindly.
That may be the fastest.